RC and co-lawyers provide services in the subfield of strata and subdivision. In this subfield of law, our firm provides guidance to owners corporations, residents and service providers on matters relating to owners corporation disputes. Guidance is provided through legal advice and representation in tribunal or court hearings. We also provide guidance by attending and or communicating with the relevant stakeholders in that industry. If you have any questions in relation to complex strata and subdivision matters, please do not hesitate to contact us at RC and co-lawyers.
Good morning, Strata enthusiasts. Welcome to Live Breakfast with Managers Strata Law Week. I am Ria, here to present the host of this morning's live stream, Rochelle Castro, Strata lawyer.
Good morning, all. Good morning to our Breakfast with Managers Strata Law Week. My name is Rochelle Castro, Strata lawyer, and I'll be hosting this 4-day Strata Law Week event, spending breakfast with managers and all the other stakeholders in the strata industry here in Victoria, Australia. The purpose of this live breakfast with managers Strata Law Week is to help out and educate those in the strata communities about the changes in the Victorian Australia strata laws. So let's get started. I will now bring up my slides. Next slide. So there are amendments to the 3 laws that you see in this slide. That's the Owners Corporations Act 2006, Retirement Villages Act 1987, and Part 5 of the Subdivision Act 1988. At the end of this week, we will also be sharing the recently approved Owners Corporation Regulations 2021. It does come into effect tomorrow, 1 December 2021. So what better way to start the week off with this live stream Breakfast with Managers Strata Law Week. Next slide. Let's get started. So we will be discussing this morning briefly parts 2 and parts 3 of the Owners Corporations Act, particularly the functions and powers of the Owners Corporation, and also the changes in the financial management of the Owners Corporation. And you can see there divisions 1 to 5 of part 2 of the Owners Corporations Act. There are amendments. And part 3, financial management of the Owners Corporations Act, divisions 1 to 6 are also amended. Next slide. So first of all, one of the main changes in the Owners Corporations Act, or the Act, as I will refer to this morning, are the 5 tiers of the Owners Corporation. Today, we only have 2 kinds of Owners Corporations. We have the prescribed Owners Corporation and the not prescribed Owners Corporation. That will change effective tomorrow. And the changes are the Owners Corporation will have 5 classes. That's Tier 1, which is more than 100 occupiable lots, and it's not the services-only Owners Corporation. Tier 2, which has 51 to 100 occupiable lots, and is not a services-only Owners Corporation. Tier 3, which has 10 to 50 occupiable lots, and is not a services-only OC. Tier 4, which has 3 to 9 occupiable lots and is not a services-only OC. And Tier 5, which is a 2-lot subdivision or is a services-only OC. Services-only OC is actually relating to OCs which has no land or building, and either the developer or what we call the initial owner arrange for a utility company to install common meters so as to designate as common property, or the subdivision has a common supply or common service that is unmetered. Next slide. Section 18 is amended, and that relates to legal proceedings. From 1 December 2021, the Owners Corporation has always, according to subsection 1, must commence any legal proceeding unless it is authorized to do so by special resolution. So they cannot comment unless a special resolution is passed. Subsection 2 is the amendment, wherein if a matter is within the civil jurisdictional limit of the magistrate's court, an OC is authorized to issue legal proceedings in that jurisdiction magistrate's court by ordinary resolution if the OC is issuing proceedings within that relates to debt recovery within the limits of the magistrate's court, which is up to $100,000, or it relates to rules enforcement. So they can issue legal proceedings with ordinary resolutions in the magistrate's court, in VCAT, or any other appropriate tribunal, or a court of another state or territory that corresponds with the magistrate's court. Next slide. Common seal. There's also an amendment on that. So Section 10 of the Act is replaced. It removes the requirement for the common seal. The OC may, in its own name, on behalf of its members, execute any document or do anything necessary to allow them to function and to exercise their rights and obligations and carry out their obligations without the common seal being placed on the document. An OC may also authorize a document to be executed at least by 2 lot owners of separate lots. So they would sign on behalf of the OC. Next slide. The new Section 18A of the Act, the OC is not required to have a common seal. And if there is a common seal in place, Sections 19, 20, 21, and 22 would still apply in respect of the use of the seal. But an OC that has a common seal may, by ordinary resolution, determine that the common seal is no longer required and can be destroyed. They could actually pass that resolution using or passing an ordinary resolution. Next slide. Water. There's a new Section 17A, which relates to water on common property. So any rainwater or other water that falls, occurs, or flows on common property, whether unless it is coming from a waterway or a bore, is taken to be part of the common property. The water can also be used for its own purposes according to the decision of the OC. Next slide. Fees. In the new Section 23, subsection 3, subsection 3A, subsection 3B, in relation to annual fees, which has always been the practice, fees must be calculated according to lot liability. The new section, subsection 3A, the OC may levy fees on being an additional fee on a lot owner if the OC incurs additional costs in relation to the use of a particular lot. An annual fee would not adequately take account of those costs, which will allow the OC to charge on a particular lot owner that relates to the use of that lot. The new subsection 3B relates to any additional fees under subsection 3A, and that is fees must be levied on the basis that the lot owner who benefits more from the use of the lot would end up paying more. So the OC is given that additional entitlement to do the levying in that way. Next slide, please. Fees for insurance. In addition to the annual fees or the annual operational budget, there is a new Section 23A, wherein the OC can levy fee to cover costs of premium for reinstatement and replacement insurance. That must be based on lot entitlement. And I do highlight the words lot entitlement. Next slide. Going and continuing on fees for insurance, in addition to annual fees, the OC may levy a lot owner a fee to cover cost of excess or increased premium resulting from or attribute to a claim if the claim caused by a culpable or willful act or gross negligence by a lot owner, lessee, or a guest. Further, this levying that allows the OC, they could levy on the lot owner in relation to damage to common property by a lot owner or a lessee where it is not covered by insurance or damage is less than the excess that would have to be payable. Next slide. Further amendments on fees for relating to extraordinary fees, which triggers Section 24. So some changes include works undertaken, changes to works carried out, which is really not a significant change to that particular provision. And there's also an additional description of what could be charged, which is fees and charges is also added to Section 24. There is a new subsection, which is Section 24, subsection 2B. The OC could levy special fees and charges on a lot owner, which relates to repairs, maintenance, and other works that arises from a particular use of a lot by the lot owner. Next slide. Maintenance plan. There's now the 5 tiers that I mentioned earlier is now triggered in relation to preparing and approving a maintenance plan under Section 36 of the Act. Tiers 1 and Tiers 2 OCs, which relates to 51 lot occupiable lots and up. And there's also, there is a requirement that they must prepare a maintenance plan. So there is an obligation. In relation to Tiers 3, 4, and 5 OCs, there is the option, which relates to 2 lots up to 50 occupiable lots. There is that option to have a maintenance plan. It's not an obligation, but there is an option to have one, to prepare and approve a maintenance plan. Section 237 of the Act may, by ordinary resolution, the OC could amend and approve a maintenance plan. This has always been the practice in my observation as a strata lawyer, but Section 237 clarifies that now. Next slide. Abandoned goods. There is a new Section 53A, and this is one of those additions that was not there before in the Act. And the OC in Section 53A allows them to dispose of goods abandoned on common property, particularly the low-value goods. Section 60 to 65 and 73 to 76 of the Australian Consumer Law and Fair Trading Act 2012 would apply, particularly, as I've mentioned, in relation to low-value goods, in relation to what has been captured in the OC Act. There is a requirement for a notice of intention to be given, left, or sent by post to the last known address, which the OC must comply with prior to disposing of the abandoned goods. Next slide. More on abandoned goods. Section 53C. The OC may move to a safe place if the goods block reasonable access to the lot or the common property. This section, Section 53C, also the OC must make reasonable attempts to communicate with a person in relation to the disposal of those goods or prior to the disposal of those goods. Section 53D, which is new, the OC must not dispose of if there is a dispute in VCAT in relation to those goods or in relation that may be in connection with those disputed goods. Section 53E, the OC that disposes of goods is not liable in relation to those goods by reason of the disposal. Of course, that's conditional on them complying with prior notices that must be issued before disposing of the abandoned goods. Next slide. That is day 1 of 4 of the amendments to the Owners Corporations Act and Owners Corporations Regulations. I will see you tomorrow with part 2 here in Breakfast with Managers, Strata Law Week. Rochelle Castro, Strata Lawyer. See you tomorrow.